मैम आपके साथ यही तो प्रोविजन सर, तो हमें नीड क्या पड़ी सेक्शन 9 की? असल में हिस्टोरिकल बैकग्राउंड मैंने आपको बताया था। हिस्टोरिकल बैकग्राउंड ये है कि ऑब्जेक्टिव मैरिज का ये होता कि हस्बैंड एंड वाइफ बोथ शुड लिव टुगेदर, and suppose this objective is going to be defeated, then here, in order to fulfill that objective, here section 9 is being made. अच्छा, तो उससे अलग ही रहना है, so why we enter into marriage? सर, बट आफ्टर मैरिज ऐसे कुछ क्लैशेस हो गई कि वो नहीं रहना चाहते साथ में। But during continuance of marriage, it is the legal provision that the party has to live together. Okay, sir. Thank you. Okay. Now let us start. I think that in last lecture I was discussing that what are the reasonable excuses. In reasonable excuses, I have just pointed out that there are the settled principle, 3 settled principles. And this settled principle is not actually legislative, it is judicial settled principle. And when it is the judicial settled principle, then we can say that it can only be enforced through the judiciary. Now is the first one. That suppose who is leaving the company of the other, then what is reasonable excuse? If the party who is leaving, that party is being called as a respondent because the petitioner has filed the petition for restitution of conjugal right, and the respondent, he is leaving the company of the petitioner. Now the respondent can take the defense that there is a reasonable excuse, and by that reasonable excuse, he wants or she wants to live separately. And here, the 3 reasonable excuse has been classified. The first one, the ground on which he is living separately. If on that ground, if that party is able to get the matrimonial relief, जिस आधार पर कोई पार्टी दूसरी से अलग रह रही है, उस आधार पर अगर वह मैट्रिमोनियल रिलीफ प्राप्त कर सकती है, तो कहा गया ये रीजनेबल एक्सक्यूज है। मैट्रिमोनियल रिलीफ क्या होती है, कल मैंने बताया आपको। मैट्रिमोनियल रिलीफ मींस द रिलीफ व्हिच इज प्रोवाइडेड इन सेक्शन 13, their ground of divorce is being provided. So here 9 grounds are provided in 13.1, 4 grounds are provided in 13.2. So all these grounds, if any of the parties living separately, then it is a reasonable excuse for that party. And here the restitution of conjugal right cannot be granted against him or her. The second I have pointed out yesterday, that suppose on the ground on which the respondent is living separately, if that ground is not sufficient for getting the matrimonial relief, but it is grave and words ध्यान में रखिएगा, it is grave and I have given the example that if you go through the 13, you will not get the divorce on the ground of AIDS. And suppose any party suffering from the AIDS. AIDS is the disease which is sexually transmitted disease. So naturally, if one party is having the AIDS, naturally he may infect to the other party. So this is reasonable ground. It is very grave and good. And the third one, here the third one, it has been pointed out under the third one, that where the guilty party means the party, the party, guilty party here means petitioner. So if petitioner is guilty for what? Either any act, omission or conduct. And by that act, omission and conduct, it cannot be expected that the other should live with that party. Act, omission and I have explained yesterday. Act means suppose he is always beating the wife, he is always coming late night and after drinking. So these are actually things which are being the act of the parties, act of the petitioner. And when this is the act of the petitioner, then here it has been pointed out that whether any person can expect that the party can live together. No. Similarly, also omission. Suppose one party is ignoring the another party and not taking the proper care. Suppose party is suffering from the fever and other party is very careless. So this is omission from the side of the petitioner. The third conduct. Suppose any conduct which is doing by one party, this is immoral. So any conduct which is immoral, then it cannot be expected with the to live with the other party. So these are the three. So far the first one is concerned. It is very plain, very simple. What are the grounds enumerated in 13? If that ground is present, any party is free to leave the company of the other party. Very plain. But so far as the second and the third, it is not very clear what is grave and with what conduct we may categorize that this act, omission, or the conduct under which the party is free. Party cannot be expected to live with the other party. So this is actually dubious. It is not very clear. Therefore, I want to explain all these through the cases. Here the cases which are being actually provided, and the first of the case I am putting before you. Here, these conducts are being actually pointed out that if the husband is doing this act or the conduct, it is grave and grave. What act and the conduct? The first one, that if the husband insisted that wife must live with his parents. So if there is a compulsion from the side of husband that wife should live with his parents, then this is a grave and guilty. Wife's reasonable apprehension that it would be unsafe to live with the petitioner. If there is a reasonable apprehension that it is not safe for her to live with the husband, then it has also been pointed out in and similarly also with the wife forcing the when husband forcing the educated wife, Brahmin educated wife to cook the meat, beef, and also to eat it, and apart from that to drink it. Similarly, also the husband having another wife, persistent nagging. Nagging means lana dena. Persistent nagging of the wife by the husband's parents. Addiction of addiction to drink and drug, accompanied with the physical violence. So these are the grounds which are being mentioned here, and it has been pointed out if the husband is doing these things, then it shall be treated that wife can live separately, and the wife is free that this is reasonable estate for her. A restitution of conjugal right will not grant. Here one more case I have put before you. The name of the case is Ramchandra versus others. This is the decision of High Court in 1987. Here actually the wife went to her parents for delivery. She was actually pregnant and the delivery was expected. And later on, the child was also born from that. And here serious thing was that the wife was under cesarean operation, and that's way thus she was able to give the birth of the child. But husband has not taken care. He never visited the wife's house. He never visited to see the child. It has also been pointed out. This is the sufficient that one is omitting. This is omission from the side of the husband. He is omitting the duty which is required to be done by the husband. Now, the name of the case is Ramchandra versus Adar. Now, another case, Ashok versus Subarnam. Here, actually, this is the case of the dowry, where the wife always put under the pressure of the dowry. She has been harassed for that. Then this also been provided. This is actually the case where this can be categorized as grave and weighty, and this is reasonable excuse for wife to live separately. So these are the few examples I am putting before you, but I am not claiming that these are the exhaustive. These are actually the list which is not exhaustive. The list is very narrower. There are so many other cases also. Now, now one thing, burden of proof. I think that I have already explained. I think that this would be repetition. Firstly, the burden of proof in restitution cases lies on the person who wants that restitution degree of restitution may be granted in his or her favor. Once it is being proved to them, burden of proof shifted from that person to other party. That other party should prove that there is a reasonable excuse to live separately. Now, I am just in the beginning when I have started the class. One of your classmates argued, I think that she is Yukta Yadav. She arguing that what is the need of such thing? A person actually being compelled against his or her desire to live with the other party. Then her argument was that this is against the individual right. Now, in this line, I want to point out, I think that you have studied the constitutional law. Come out. Have you studied the constitutional law? Yes. So actually, constitutional law, there is one article, and the article is Article 21. This article is known as personal liberty. No person shall be deprived of his personal liberty except according to the procedure established by law. Here, personal liberty, I think that if you go through this cases, you will get so many cases in the personal liberty. So many cases under the personal liberty. So now, the question is, under section 9, a person is compelled to join the company of other, whether this is not violation of the personal liberty. Just arguing by one is so that whether it is reasonable that compel the person to live with the another. So on this, there is cases, and the case which I want to put before you, the name of this is T. Sarita versus T. Venkata Subbaiah. This is the decision of the Andhra Pradesh High Court. This is the decision of 1983, Andhra Pradesh High Court. Fact of the case was very interesting. Actually, a marriage took place when bride and bridegroom were minor. This was a child marriage. As per custom of the society, wife joined the company of the husband, but unfortunately, the treatment of the husband and the relative of the husband towards the wife, that treatment was not good. She was actually being ignored. Sometimes she was being harassed. Proper food and clothing were not supplied to her. Now, one day, she decided to leave the house. His name I have just given T. Saritha, Aretha. The Saritha versus T. Dot Venkat Subbiya, Venkata, Venkat Subbiya, Subbiah. This is the case, no doubt. Very interesting case. So I was pointing out the fact of the case. After the marriage, the wife was being ignored by the husband, relatives of the husband, proper food was not given, proper clothes was not given, she was being beaten. One day she decided to left the house of the husband. Now she left the house and she actually moved for searching the employment. She was very fortunate. She got the opportunity in the film city, and after doing some work, she became a star in the film city. When she became a star in the film city, now the husband, after being aware, of this fact, filed the suit for restitution of conjugal violence. Intention was very clear. He was interested that the wife should be compelled to live along with the husband. What was the intention? Intention of the husband was when the wife would be compelled to live with him, naturally he would also be able to have all the facilities which the wife was having at that time. So actually he was interested for luxurious life. He thought that better he approached to court that wife should be compelled to live with him. This was simple case. Fact is very interesting. Now decision, Andhra Pradesh High Court decision. This is very important one. Here the Andhra Pradesh High Court pointed out that Section 9, it is unconstitutional and it is why. Why it is unconstitutional and why? The reason was given by the Andhra Pradesh High Court because this is against the personal liberty. And as you are aware well, here the personal liberty, this clause also proves a right of privacy. Now this is the right of the privacy of every female. She should decide. She should decide when her body is able to procreate another human being. So this will be decided by whom? This will be decided by the wife herself. Now if she will be compelled to live with the husband, naturally this liberty is being snatched away. When she will live with the husband, naturally this is the normal course that she may be pregnant. And it means what? Indirectly she had been compelled to be a pregnant lady. So now the decision which is given in this case, that is very interesting decision. Here he pointed out that if the wife will be compelled to live with the husband, naturally this is a violation of right to privacy. Because every female has a right to privacy. She should decide when she wants to be mother. And if she will be compelled, then naturally this is a violation. So this is the one case where the Section 9 has been declared as a null and void. Okay, it is pointed out that Section 9 did not promote any legitimate public purpose based on any concept of Section 9, any concept of social good, and thus arbitrary and violative of Article 4. Are you able to understand this? Any person having any doubt? Case is very simple, very clear. But unfortunately, what happens later on. After that, another case came before the Punjab and Haryana case. The name of the case is Harvinder Kaur versus Harvinder Singh. This is not Punjab and Haryana, this is the Delhi High Court decision. 1984. Harvinder Kaur versus Harvinder Singh. And simultaneously, another case also decided by Supreme Court in the same year of 1984. The name of the case is Saroj Rani versus Sundar Singh. Now, here in Delhi High Court, the justice was Awadh Bihari, and in the Supreme Court, the justice was Sabya Singh. Later on, he became Chief Justice of. Both were of the same opinion. What judgment delivered in Harvinder Kaur case, the same judgment has been delivered by the Supreme Court, and we can say a repeated judgment is being delivered by this, reiterated the same. What is that? Here it has been pointed out that Section 9, what is the objective? The objective of the Section 9, that a strange party should be made nearer to each other. यानी उनमें जिनमें बिखराव है, उन पक्षकारों को स्ट्रेंज माने जिनके बीच का रिलेशन स्ट्रेंज है, बिखराव है, उनको जो है एक साथ लाया जाए, जिसका यही ऑब्जेक्टिव है. दिस इज द मेन ऑब्जेक्टिव. दिस इज द मेन ऑब्जेक्टिव. Now, here it has been pointed out that objective of the Section 9 is bias because it fulfills the objective of the marriage. Because what is the objective of the marriage? The objective of the marriage is cohabitation and consortium. With this objective, the marriage is actually being there. So therefore, it has been pointed out that the parties should live together. Even though they have no sexual relations, but it is required that they should have to live together. There are so many arguments are given against this case. This decision was the Supreme Court decision. It was pointed that when the parties have no any sexual relation, then why and how much a person will tolerate? But in spite of that, this is the decision. And now again, the law which was declared null and void by the Andhra Pradesh High Court, that law again been reinstated, regenerated by the decision of the Supreme Court. Any doubt? No, by any person come out? Difference between cohabitation and consortium. Cohabitation, actually, there is a requirement that parties should live together. Consortium means there must be relationship between them that should be good relations. You can say gentleman. Any more questions? Now, one thing more I want to know from your side, whether you are studying the civil procedure code. You are not also. Hello? Hello? My question is, are you studying the civil procedure? पढ़ चुके हैं, तो बहुत अच्छी बात है. This is very good. And if you have studied in the last semester, then I think that you have a good idea about the civil system में सवाल तो बाद आप अरे भाई पढ़ा नहीं होगा नतीजे से मिला होगा। चलिए कोई बात नहीं, मैं अपना पॉइंट आपके सामने रखता हूँ। आप पढ़े हो तो भी अच्छा है, नहीं पढ़े हो तो आप क्या। आप ऑर्डर 21 में देखें, तो ऑर्डर 21 में एक पार्ट है जिसमें ये बताया गया है हाउ द डिग्री कैलकुलेशन ऑर्डर 21। I think that the rule will start from this. Sorry, rule will start from the rule 30 onwards. So if you go through the rule 30 of order 21, so you can get different type of decrees are being given, that how they may be executed. How they may be executed. These are the decrees which are being. Now, under this, there is one provision which is provided, that is 30. If you go through the 32, you will get that how the degree of restitution of conjugal right has been executed. Mode of execution. What is the mode of execution? If the degree of restitution of conjugal right is being actually passed, then the mode of execution, the way in which it can be executed, this is the one way. What is that? The property of that particular person or the judgment taker may be attached. If he is not obeying the decree of the conjugal right, the property will be attached. Decree of the specific performance restitution 32. But I am confining only to the restitution of conjugal right. How the decree of the restitution of conjugal right may be enforced, may be executed. The way is given that if the judgment debtor is not obeying the decree of the restitution of conjugal right, the property of the judgment debtor may be attached. And suppose continuously it has been attached for 6 months, then decree holder may apply to the court, and the property which is attached, he may request that property should be restored. So this is a way of execution of decree of the restitution of conjugal right. कैसे डिक्री एग्जीक्यूट होगी? एक ही तरीका बताया गया है, जजमेंट डेटर की प्रॉपर्टी को प्रूव कर लिया जाए, अटैच कर लिया जाए। अटैचमेंट अगर 6 महीना हो गया और अब भी वो नहीं एग्जीक्यूट कर रहा है, तो उसकी प्रॉपर्टी को सेल आउट कर, और जो सेल से पैसा मिले उससे डिक्री सेटिस्फाई कर दी जाए, और जो पैसा बचे वो जजमेंट डेटर को वापस कर दिया जाए। दिस इज द प्रोविजन व्हिच इज गिवन। नाउ माय क्वेश्चन, माय आर्गुमेंट इज whether in India, suppose any decree which has been passed against the wife, whether it can be executed by that method. Because here tradition is the property always in the name of the male person. So if that restitution of conjugal right is against the male, naturally it will be executed. But once it will be against the female, then whether the female has any property, most 99% female, they have no any property. How they can be attached? It means property cannot be attached. Okay. Now another provision is also given in the order 21, and that provision is 33. 33, what is written? If any restitution of conjugal right decree is passed against the husband, how it will be executed? Here the provision is given that it will be executed and the husband shall be ordered. If husband is not obeying the restitution of conjugal right decree, he may be ordered for monthly payment to the wife. And here, monthly payment, which is obligatory on the husband to give the monthly payment. And if he is not paying, then consequence will be. So this is the way restitution of conjugal right decree may be executed. So moreover, under Indian circumstances, if restitution of conjugal right decree is given against the husband, there is probability that it may be executed. Because once husband has a property, it may be attached. He may also be compelled to give the monthly allowance to wife. If he is not doing, he may be arrested if he does. Okay. Now, by that way, we are able to complete another topic, section 9, restitution of conjugal right. I am inviting question on the restitution of conjugal right. Any person having any doubt, please come out. Are you getting my voice? No, wife cannot be arrested. There is no provision for the arrest because under Rule 32, there is no provision for arrest. The provision is that her property may only be attached. And even though if she is not complying, not living with the husband, then if the property attached for 6 months, it may be liable to sue. Any more question? Any more question?
Sir, if the husband has the fraud intention, thereafter what should be?
Fraud intentions what? I just want to know exactly बताओ fraud intention में क्या करना चाहता?
जैसे सर सरिता वाला केस में था कि उसने कंजुगल रिलेशनशिप के लिए किया, ठीक, तो मतलब वहाँ पे तो फ्रॉड इंटेंशन ही ना हुआ कि अपने लाइवलीहुड को मतलब इम्प्रूव करना चाहता है. फ्रॉड में और इंटेंशन, फ्रॉड में अंतर होता है. आपके लॉ में कहीं जो है इंटेंशन पनिशेबल नहीं है क्रिमिनल लॉ. केवल इंटेंशन एक आदमी रखा है, इसके बिहाफ पर पनिश नहीं हो सकता. इंटेंशन के साथ ही साथ एक्ट होना चाहिए, तो उससे प्रूव भी करना पड़ेगा. समझिए, तो फ्रॉड में ऐसी कोई फ्रॉड इंटेंशन का कोई यहाँ कंसेप्ट, यहाँ सीधा कंसेप्ट है शादी हुई साथ साथ नहीं रह पाते हैं, कारण बताइए. ठीक है, अगर कारण रीजनेबल एक्सक्यूज में आता है तो माफ है, नहीं रीजनेबल एक्सक्यूज में आता है रेस्टिट्यूशन ऑफ कंजुगल राइट की डिग्री पास हो जाएगी आपके अगेंस्ट. आपको जो है दूसरे पार्टी के साथ रहना पड़ेगा. विष्णुकांत तिवारी, व्हाट इज योर क्वेश्चन? I disappeared. Please come out with voice.
What is the procedure if decree has been passed under section 9 against wife and wife does not have any property?
No, there is no provision. That's why I am putting the problem before.
Okay, sir.
There is no remedy because in CPC the restitution of conjugal right decree can only be executed by the attachment of property. Any more question? Okay, may I proceed from the girl side? Yukta Yadav. Hello. Hello, Yukta Yadav.
Yes, sir.
Have you any problem right now?
No, sir.
Because what your intention is according to your intention, your one decision I have referred. But unfortunately, section 9 is still valid.
Okay, sir, I got it.
Now, may I proceed to section 10? Section 10 is regarding the judicial separation. Go through this section 10. Section 10 of Hindu Marriage Act, it is like the judicial separation. What do you mean by judicial separation? What do you mean by judicial separation? Firstly, I want to explain this. Judicial separation, this is the decree which we can say this is the decree which has been passed by the court before the divorce. Why? Go through the provisions of section 10, subsection 1. Either party to a marriage, whether solemnized before or after the act, may present a petition for praying the decree of judicial divorce on the ground specified in 13.1 and 13.2. So here, under subsection 1, the power is given to the court. Court may pass the decree of judicial separation on the grounds which are mentioned under section 13.1 and section 13.2. Section 13.1 and section 13.2, here the grounds which are enumerated, these grounds also sufficient for passing the decree of divorce. But on the same ground, court is empowered to pass the judicial separation. So this is the first provision, the second provision, and the subsection 2, what is written? If any decree has been passed, now it is not obligatory on the petitioner to cohabit with the respondent. So suppose decree of the judicial separation has been passed, now petitioner is not compelled to live with the respondent. And here one more provision is attached here. What is that? If any party requests to the court, and if the court is satisfied regarding the truth of that statement made by the party, then the decree may be resigned by the party, by the court, not party. Decree may be resigned by the court. What does it mean? Second part is very clear. What the second part is telling, judicial separation decree is passed, petitioner is not bound to live with the husband. And any of the party may request to the court, now judicial separation decree may be resigned. Resign means समाप्त कर देता है. Now what is the judicial separation decree? Actually, judicial separation decree, this is the decree which is usually being passed by the court. In our test, whether the parties they can live separately. This is the test. Once the divorce decree will be passed, marriage will come to an end. And once the marriage will come to an end, then the party, even though they are desirous, they cannot live together without marriage. So that's why divorce means what this decree divorce has impact or effect. What effect decree has? That marriage comes to an end. But so far as the judicial separation is concerned, here actually in judicial separation, marriage does not come to an end. Marriage continues. Parties are at liberty either to live with each other or not to live with each other. So this is the distinction between the decree of divorce and decree of judicial separation. So once a judicial separation decree is being passed, now parties are free. They may live together, they may not live. But the marriage will continue. The tie of the marriage will not come to an end. Marriage will continue. But so far as decree of divorce is passed, marriage comes to an end. शादी खत्म हो जाएगी एकदम, और इट इज नॉट पॉसिबल फॉर टू लिव टुगेदर. So this is the actual distinction, and that's why mostly in most of the cases the court firstly passing the judicial separation decree in order to test whether the party can live together or party can live separately. And once judicial separation decree has been passed, now on the same basis, here the court may pass the decree of divorce decree. So provision we have in this Hindu Marriage Act, and that provision I want to put before you. One provision is 13(1)(a), and another provision is 13(a). If you go through the 13(1)(a), here the provision is very plain and simple. If judicial separation decree has been passed and 1 year has elapsed, if judicial separation decree has been passed and 1 year elapsed, then the party may move for the decree of divorce. And 13(a), what is written? If you go through the provision of 13(a), what is written? In 13(a), it is written that the court, before passing the decree of divorce, may pass the judicial separation decree. The exception is given only 3. What are these 3 exceptions? If the ground of divorce is apostasy, change of religion, or the ground of the divorce is renouncing the word, or third, if the ground of divorce is presumption of death, party not for 7 years. Except in these 3 grounds, if the petition is being filed for the decree of the divorce, then the court, instead of passing the decree of divorce, may pass the judicial separation. Then what is the difference between the judicial separation and the divorce decree? The difference is very clear. In decree of divorce, marriage comes to an end. But in judicial separation decree, marriage does not come to an end. Marriage will continue. Parties are free. They may live together, they may not live together. What is the objective of this judicial separation decree? The objective is just to give an opportunity to the parties. पहले ही मुकदमा दायर करें और पहले ही डाइवोर्स दे दीजिए तो क्या होगा? बाद में अगर उन्हें पछतावा भी होता है तो क्या करेंगे वो? इसलिए ये प्रोसीजर बनाया गया कि डाइवोर्स डिक्री पहले न पास करके जुडिशियल सेपरेशन की डिक्री पास किया जाए. इससे क्या होगा? इससे फायदा ये होगा कि पार्टी जो है पहले ये तो निश्चित कर लें कि उन्हें अलग रहना या नहीं रहना. कभी कभी हीट ऑफ पैशन में डाइवोर्स का सूट फाइल हो जाता है और बाद में क्या होता है, पार्टीज पश्चाताप करती है. तो उससे बेटर क्या है? उससे बेटर यह है कि पार्टीज को पहले अपॉर्चुनिटी दे दी जाए साल भर की, अलग अलग रहें, और अगर वो डिटरमिनेट हो जाते हैं कि नहीं उन्हें अलग ही रहना है, दे कैन प्रोसीड फॉर द डाइवोर्स एंड द डाइवोर्स पास. So this is the distinction between judicial separation and divorce. क्या लिख रहे हैं? Please, section C. Some question was asked, but actually I was not able to read out. Come with voice.
Hello, sir. My question is, sir, any certified time period for judicial separation decree?
सर्टिफाइड पीरियड मैंने 1 साल का पीरियड दिया हुआ 13(1) में देखें 1A में प्रोविजन, उसमें लिखा हुआ है कि अगर जुडिशियल सेपरेशन की डिक्री दी जाती है तो साल भर के बाद इसी के आधार पर डाइवोर्स डिक्री के लिए पिटीशन दायर किया जा सकता है, यानी डाइवोर्स डिक्री पास हो सकती है.
Okay, sir. Thank you.
एनी मोर क्वेश्चन? तो दिस इज सेक्शन 10. और अच्छा एक बात और है, सेक्शन 10 का जो सेकंड पार्ट उसमें ये लिखा हुआ लास्ट में कि अगर पार्टी रिक्वेस्ट करे कोर्ट से तो ये जुडिशियल सेपरेशन की डिक्री क्या हो सकती है, रिजाइन हो सकती है। रिजाइन माने इसे समाप्त किया जाएगा। यानी कि अगर कोई एक पार्टी अगर जो है रिक्वेस्ट करे न्यायालय से कि अब हम साथ साथ रहना चाहते हैं, तो कोर्ट क्या करेगी, जुडिशियल सेपरेशन की डिक्री को समाप्त कर देगी और पार्टीज फ्री हो जाएंगी साथ साथ रहने। एनी मोर क्वेश्चन?
सब मेंटेनेंस मिलेगा?
हाँ, दोनों जुडिशियल सेपरेशन में देखिए मेंटेनेंस तो डाइवोर्स के बाद भी मिलेगा। 109, आर यू गेटिंग माय वॉइस?
यस सर।
हाँ, मेंटेनेंस तो जुडिशियल सेपरेशन में तो मैरिज तो कंटिन्यू हो रही है, तो मेंटेनेंस तो मिलेगा ही। डाइवोर्स में भी जो है मैरिज कम्स टू एन एंड बट द वीकर पार्टी में क्लेम दी मेंटेनेंस। यहाँ पर हस्बैंड और वाइफ दोनों एकदम है, जो भी वीकर होगा, जिसके पास फाइनेंशियल वीकनेस होगी, वो दूसरे से मेंटेनेंस मांगेगा।
ओके सर।
नहीं, हाँ, जुडिशियल सेपरेशन अपने आप खत्म तो हो जाता है जब पार्टीज दोनों साथ रहने लगे, तो जुडिशियल सेपरेशन का कोई मतलब नहीं रहता है। लेकिन बेटर है कि कोर्ट से जुडिशियल सेपरेशन की डिग्री को समाप्त करा लिया जाए। ओके, हाँ, वंस डाइवोर्स डिग्री इज गिवन, ये मुस्लिम लॉ नहीं है, यहाँ पर दूसरी शादी हो सकती है। मुस्लिम लॉ में जरूर है कि अगर तलाक हो गया तो वही लोग दूसरी शादी नहीं कर सकते। कब तक? जब तक कि वाइफ दूसरी शादी न कर ले और मैरिज कंजमेट न हो जाए और वो डाइवोर्स न कर दे, तब तक तो फिर पार्टी शादी नहीं कर सकती। लेकिन ऐसा कोई प्रोविजन हिंदू लॉ में नहीं है। पार्टीज आर फ्री टू रीमैरी। एनी मोर?
देखो टाइम पीरियड होगा रीमैरी करने?
कोई टाइम पीरियड नहीं, डाइवोर्स डिक्री हो गई, जब मंजूरी करे तब जो है वो रीमैरी कर सकते हैं। अरे भाई जुडिशियल, हाँ, जुडिशियल सेपरेशन की डिक्री जब तक है, देखिए दिस इज आल्सो डिफरेंस बिटवीन जुडिशियल सेपरेशन एंड डिक्री ऑफ डाइवोर्स। इन डिक्री ऑफ डाइवोर्स marriage comes to an end. Marriage comes to an end. Parties are free to marry with the other person. Here, this will not be case. But in judicial separation decree, the marriage does not come to an end. Parties are not free to marry with any other outside party. One year is written here, 13(1)(a). Time is written 1 year. So this is very important. Judicial separation means marriage is continued. And once the marriage is continued, you are not allowed to marry with the outside person. Otherwise, this will be a case of bigamy. Okay?
Okay sir, thank you sir.
Any more question? So now, next topic I want to start, but time is not permitting me. We have only 2 or 3 minutes in our hands. But I just indicate you that tomorrow we shall discuss the wide and wideable marriage. And from that, we shall enter from wide marriage to what's the wideable marriage. So I think that only 2 or 3 minutes remains in our hand. So if I am starting today wide and wideable marriage, provision I can very well say you, section 11 is a wide marriage and section 12 is wideable marriage. So far as the wide marriage is concerned, we have already discussed it. When I was discussing the first element for a valid marriage, what was the first element of valid marriage? that parties to the marriage should not have any other living spouse at the time of marriage. It means condition was that here monogamy is prescribed, bigamy has been prohibited. On that time, I have pointed out what is the meaning of bigamy. I have already explained cases of the bigamy. I have also explained. The second ground under section 11, what is provided if the parties are within the prohibited degree of relationship. I have already explained what are the prohibited degree of relationship. Consequence, I have also explained. Marriage will be void when I was discussing section 5. The third ground is that parties should not be subpoenaed with each other. So if the parties are subpoenaed with each other, then again the same happens. And the marriage shall be categorized as a void marriage. So I have discussed void marriage fully when I was discussing section 5. Consequences I have pointed out. Here the provision also given under section 17 and 18 for punishment. If the parties are committing the bigamy, punishment is given 494, 490, 495. If they are in the separate relation, punishment is given. If they are in prohibited degree of relationship, also punishment is given in section 8. So today I think that this is sufficient. Tomorrow again we shall start with the scheduled time. Please disconnect yourself.